I'm Peter Rubin, and I'm thrilled to be moderating this panel today with four outstanding, interesting, and experienced panelists. We're going to be talking about rights without remedies. And this is a topic, that really ranges exceedingly broadly from basic precepts of standing up to, as recently as yesterday's habeas decision, talking about the availability of judicial recourse for detainees. What we're going to focus on today has to do with a centrally important aspect of American law, which is redress for wrongs done to individuals, particularly people who are injured, consumers, employees, people who are subject to discrimination, or to other kinds of wrongful conduct. And the question we're going to explore has to do with, I guess broadly speaking, the current approach in American law toward access to courts and to redress for grievances. Long ago it was said that there is no right without a remedy. And the question we're going to explore, I'm hopeful today, is do we now have a situation where there are rights that have no remedies? What are the reasons for the shape that American law has taken over the past maybe 20 or 30 years with respect to some of these issues? There are detailed biographies of our panel members in your programs. I'm going to just briefly introduce each member as I turn to him or her for the first time. We're going to talk ourselves for maybe 45 minutes or so and then open up the floor to questions from you. Let's begin. I'm going to begin with you, Marcia Greenberger. You are the founder and co-president of the National Women's Law Center. You've been deeply involved both in the legislative process and in litigating questions with respect to equal rights for women for at least more than 2 decades, maybe more than that. Maybe you can start us off by talking a little bit about what it is that our sort of topic encompasses here. What are we to make of restrictions that have been put on individuals' ability to sue under various provisions of law? And in particular, maybe you can talk about what some of those limitations are. We have limitations on what are called private rights of action, the ability of individuals to sue under federal statutes. We have limitations on suits against the government under a case called Gonzaga versus Doe that the Supreme Court decided in the last decade or so. We have quite dramatically, and it was mentioned at this morning's program, a limitation on the ability to sue for equal pay, for pay discrimination under a statute of limitations decision issued last year by the Supreme Court in the Ledbetter case. Maybe you can sort of talk to us about the shape of the limitations that have been placed on individuals' ability to sue.
Well, Peter, thank you. You really gave a very good overview of the potential enormity of the topic that we're going to all be struggling with this morning. So I'm just going to take actually a narrower slice at it from my perspective as somebody who's worked for an organization that has been trying to either use the law in court or, as Peter said, craft and shape laws that are passed by Congress and get government enforcement of those laws. So it's sort of a circular effort of getting the laws passed, getting the agencies to enforce them and interpret them properly, getting them enforced in the courts so that there actually are rights, and then there are remedies, and then there's change that comes as a result. Needless to say, during all of these years, there have been a lot of glitches in this effort, and it appears in many respects more and more of these glitches piling on that makes it all the more difficult to vindicate hard-won rights. One of the key things that I'm going to start really briefly just to say with respect to a private right of action, that it used to be in the good old days that I remember litigating under or within that Congress could pass a generally worded statute that established rights not to be discriminated against, for example, on the basis of race, national origin, sex, disability, age, core civil rights statutes, starting with Title VI of the '64 Civil Rights Act, and then Title IX, prohibiting education discrimination in '72, followed that '64 model, and then age discrimination and disability discrimination was in '73. Congress never said in these statutes, and you, if you are discriminated against in violation of these statutes, can go into court and sue the covered entity that's discriminating against you. But the courts interpreted the structure of the statute and the underlying purpose of the statute to imply a private right of action, so that people had the right to go in and sue school districts that were discriminating on the basis of race, or universities that were discriminating in athletic programs on the basis of sex, etc. The implied right of action, this Supreme Court, and I have to say in some of its prior iterations as well, has said is almost a thing of the past. And that's where Gonzaga and some of these other cases have taken us, that if Congress doesn't explicitly say it's a statute that can be enforced by going to court, we can't expect the Supreme Court easily to be interpreting and implying that that was congressional intent. So we're ending up, because of the legislative process, with a number of very important statutes like No Child Left Behind, for example, which is a subject of a lot of litigation now, about what's enforceable in court based on all of the seeming mandates that come out of a statute like No Child Left Behind. If we get health care reform in the future, what's going to be enforceable if people have a right to coverage? Can they go into court and enforce it? Do they have to rely on the government to enforce those rights, or they won't exist? There's a whole second panoply of decisions that have made it harder to go into court to enforce rights oneself. That has to do with the kind of remedies that you can get in court. As a practical matter, it works out in two different ways. First of all, sometimes if you can't get a damages remedy in court, then there's no remedy the court can give you. And a prime example of that is sexual harassment. If you have been sexually harassed on the job, you may not have lost pay, you may not have lost a promotion, but your life may have been made miserable over many months, years, etc. And we had a number of situations where women ultimately left the job because they couldn't tolerate the harassment anymore. Well, if a court couldn't enjoin the employer from stopping the harassment in the future because you weren't in the workplace anymore, and you didn't lose pay, and you didn't lose a promotion, the court was without a remedy. So we had cases of women who had proved that they were sexually harassed for years in a vicious way, and they had to pay the court costs of the other side because they couldn't get a remedy. We got damages under Title VII in 1991, the Civil Rights Act of 1991, which was the first time, and part of the reason, and I have to say, it had to do in part with the legacy of Anita Hill, among other things, that gave that statute a boost. to allow for damages. But it's got caps on the damages, $300,000 for the biggest employers in the country. There are also a lot of restrictions on attorney's fees awards for these kinds of cases. So where does that get you? Very difficult to get lawyers who will bring the cases, because it's very hard now. It's harder and harder to get attorney's fees awards that really cover lawyers' time and expenses. And with the caps, it's very hard to expect that there'll be a significant jury award or court-ordered award that a lawyer can get a percentage of. So that makes it practically very hard because of the whole constellation of court decisions around attorney's fees, congressional decisions around caps or the availability of damages to ever get into court to begin with. And that's going to get me briefly to Ledbetter. And I could talk a lot about other things, but I'm going to stop with Ledbetter just to add. It's and probably a case that many of us will talk about in many panels, because it's endemic of a lot of problems, including rights without remedies. So as you heard this morning, here's Lily Ledbetter, works for Goodyear Tire, over 20 years, finds out by an anonymous note that, lo and behold, she's been discriminated against in pay for all of those years. She sues, gets a jury award of $3 million because of the extreme pay discrimination. Every man in the job over all those years got paid more than she did, no matter how junior. Her pension was reduced. The gap kept getting bigger because every percentage increased salary that she would get was based on a smaller base salary to begin with. Her overtime was lower because her salary base was lower, on and on. Well, first of all, the $3 million award gets reduced to $300,000 because of the cap. So it's barely a slap on the wrist for Goodyear. Secondly, ultimately, the Supreme Court takes the whole award away by a 5-4 decision saying, because she didn't file a complaint with the EEOC within 180 days of the first discriminatory paycheck. In other words, when she was hired, within 6 months, she didn't complain immediately that she was getting discriminatory pay. She lost her right to equal pay under Title VII forever after, for as long as she stayed an employee of Goodyear. So they could announce publicly to her from then on, yep, I'm discriminating against you on the basis of pay, be fine. So where's the right to equal pay under those circumstances? So, and I will, there are a lot of other cases where Sandoval and others that perhaps other people will talk about, where regulations that prohibit discrimination are no longer able to be the basis for a private right of action in court, and the list goes on. So what we are finding more and more is that what we thought was a whole network of rights, certainly in the area of discrimination, that were the bedrock of our ability to be protected against discrimination and to sue, have been chipped away, chipped away, chipped away. And while I won't go into this now, but maybe we can talk about it a little later, that leaves us with a reliance on government enforcement for these rights, and we have at the same time been narrowed in our ability to go into court and sue the government for non-enforcement, even intentional non-enforcement of these laws.
Okay, so Marcia says that Ledbetter is endemic or indicative of a wide range of problems here. I'm going to turn to you, Neil Mullen. You're the co-chair of the appellate practice group at Paul Hastings, Janofsky, and Walker. You represent employers, often before the Supreme Court, and you represented the U.S. Chamber of Commerce before the court in the Ledbetter case last year. I wonder if you can respond from the employer's perspective with respect to this question of, first of Ledbetter specifically, because I think that that's of sort of immediate interest, and as Marcia described, in Ledbetter, essentially what the court said was the statute of limitations begins running when the decision to discriminate with respect to pay is made and runs out, even if one continues to receive paychecks that are discriminatorily low for years in the future or an infinite period of time, whatever it is, that the statute of limitations begins running with the decision that's made. Maybe you can talk about that. Also, maybe you can also address, although this may be too broad and it's your call, the question about private rights of action, because Marcia also said that there was a time when statutes that created rights were thought to create remedies, and that that's no longer the way the court is construing statutes. And she raises the specter that I'm sure everyone here is very interested in, the specter of under a health insurance regime that is right now only imaginary, essentially. But so if there were some type of mandatory health insurance or some type of program like that where employers would be a part of it, maybe there would be no right of action for individuals, and maybe talk about how the private right of action cases might be viewed from that perspective.
Okay. Sure. The rule that attaches primary significance to the decision rather than the consequences is not a new rule. It didn't originate in Ledbetter. It's been the rule emanating from the Supreme Court as long as the Supreme Court's been deciding Title VII cases. Just as an individual can't sue over a denied promotion because the paychecks they receive are diminished by that decision 3, 4, 5, 10 years down the road. This is exactly what the Supreme Court said in Ledbetter. I think my friend Marcia left out an important fact as she recited the chain of events. She said that Ms. Ledbetter received this note, she learned that she was being discriminated against, and then she sued. The piece that she missed there was I think it was 18 years that ended the retirement decision that came in between those two events. Now, I was really very surprised at the vehemence and the rancor that the Ledbetter decision engendered. From constituencies that one can reliably expect to believe in procedural justice and the importance of due process, this seemed to me to be just an odd consequence. What ended up happening in Ledbetter was that Ms. Ledbetter, and we have to assume it's true what she claimed in terms of the wrongful conduct because the jury found for her, was that this individual, a manager, put pressure on her to have sex with her, and that when she refused, he retaliated against her by giving her lower pay increases. This is something that she testified at trial. She knew at the time the decisions were being made. She didn't file a charge. And instead she waited until she had decided to retire to file a charge to challenge every pay decision that had been made about her for her entire career. Now, by the time the case was tried, the manager who allegedly engaged in this harassing conduct, or who did, I think we have to assume that he did, was dead. So she gets on the stand and she said, the manager said this, the manager did this, I was put in this position, and there's no one there to deny or explain what the conduct was. Now, it seems to me to be sort of a self-evident principle of due process that in every cause of action, in every type of civil litigation, there's a limitations period. That limitation period, by definition, cuts off valid rights. It's the purpose of the statute of limitations. The reason we have that is that at some point, the right of the defendant to defend against an allegation takes precedence over the plaintiff's right to sue on it. And if you have a situation in which a plaintiff could be hired at a discriminatory wage rate on July 2nd, 1964, work for an employer until this year, retire, and sue over the decision that was made 40-some years ago, it's a fundamentally unfair construction of the statute. Now, Justice Ginsburg in her dissent pointed out, and I think this is a very interesting and important point, that pay cases are somewhat different from a promotion case or a discharge case. When you get fired, you know it. It's not a secret. Whereas the companies typically don't share compensation information broadly, and so you may not know that you are at a pay disparity? There are two answers to that. First of all, that wasn't the Ledbetter case. And whatever observations Justice Ginsburg had to say about that situation, it could not have affected the holding in that case. Because in that case, the evidence was undisputed that Ms. Ledbetter did know about it, knew about it for years, complained to others in her family and at the company, never went to HR, never filed a charge. So whatever problem is engendered by that phenomenon of the workplace, it didn't happen in Ledbetter. It didn't apply in that case. That's number one. Number two, there may well be, and I think reasonable minds could agree, that there's an issue with respect to when the limitations period ought to run in a situation in which the charging party or the ultimate charging party had no real reason to know about the pay disparity. And there's actually a Republican-sponsored bill in Congress right now. It's the competing bill to the Lilly Ledbetter Act, which would establish a knew or should have known standard for pay cases, which would address, clumsily, it's true, it's a very difficult inquiry. It requires judges to do lots of fact-finding. It's not a perfect solution. But it would address, at least in some rough justice sort of way, the problem that Justice Ginsburg identified in her dissent. The answer cannot be there simply is no statute of limitations in pay cases. And you can sit on your rights for your entire career, file a charge when you retire, and go back, reach back years or decades to challenge decisions on which the records have disappeared, the involved managers have long since died, been fired, quit, moved out of the jurisdiction. It really leaves the defendant defenseless. That's, I think, is the sort of the employer's view about the Ledbetter problem. Now, as far as the private right of action is concerned, I'm a big fan of private rights of action. I think that they ought to exist. I'm not so much a fan of implied rights of action. This is a problem that can easily be resolved. If Congress wants there to be a private right of action, they can say so. They know how to do it. They do it every term. Every term they pass a statute that contains a private right of action, at least one. I suspect that the next Congress will pass 8, 9, 12, 40, 50 of them. It's really not a problem. Now, the response I tend to get from folks at the plaintiff's bar is that, well, it's difficult in the legislative process to get a bill through committee, through both houses of Congress, to the president, and get it signed with a provision in it that provides for a right of action. They tend to be too controversial. But that's a confession rather than an argument to me. Because basically what that tells me is that we couldn't accomplish it through democratic means. And what we'd really like to do is to have some judge with life tenure invent a cause of action for us that we couldn't get in the negotiating process or the legislative process. So that seems to me to be sort of a problem for which the search for a resolution should be very quick and very easy. And, you know, if there are some issues, rights that Congress chooses to create and decides that the most effective and efficient mechanism for addressing them is not a private right of action but is government enforcement or some other mechanism, then they ought to fund that other mechanism. It ought to be an effective mechanism rather than a toothless mechanism. But Congress is really, and we send these people to Washington to decide whether to create rights and if so, how they ought to be vindicated. And I think that, you know, it's probably really good in the same way you treat your children. You need a little tough love. You need a little discipline. The courts ought to be telling Congress, no, we're not going to do this for you. You know how to write sentences in the English language. It's not that difficult to create a private right of action. And if you want one, do it. And if you don't do it, don't come to us complaining that the statute is not interpreted in the way that, you know, the minority report thought it ought to be, or even the majority report for that matter.
Well, this is an interesting question. I'm going to, I think eventually we'll circle back around to Ledbetter because I think there's probably more to be said about that. But I want to start by turning to you, Victor. Victor Bolden is the General Counsel of the NAACP Legal Defense Fund. You've litigated discrimination cases at all levels of the federal courts. And you've just heard Neil say that there should be essentially a clear statement rule for private rights of action. That the default position should be no private right of action is created when rights are created by statute, and that Congress should have to put this explicit language in before individuals can sue to vindicate rights that are created by statute. Is that, he's also described some of the political issues that arise when one tries to get such language in a bill, and I think that his position would be, yes, exactly, it's supposed to be a democracy. If you can't get the thing passed, you can't get it passed. But of course, well, I'll let you, I guess I'll let you respond to that, and let me also just put this gloss on my question, which is this, is the imposition of such clear statement rules, is that an appropriate way of interpreting statutes? And is this an appropriate judicial act to engage in what Neil has called tough love with the legislature?
Well, let me say this. I think that, in short, I think Neil is wrong. But but to expand on that, and actually let me just say one other thing, is that I think that this panel is described as sort of rights, without remedies, and I actually think it's really more in a better description, which I think goes to what Neil was talking about. Maybe we should call it sort of rights without the remedies you expect. In that there's a sense where I think in all of these decisions, you look at Gonzaga, you look at Ledbetter, you look at a host of these decisions, and what the court doesn't actually say is, oh, they can't do anything. They say, well, it's just the remedy that you actually would expect people to have, that you would expect Lilly Ledbetter to have, which would be redress for pay inequities. And in Gonzaga, the remedy you would expect. Now, and with Gonzaga, it's a very interesting case, Gonzaga v. Doe. The underlying statute is entitled, it's FERPA is the acronym, but it's entitled the Family Educational Rights and Privacy Act. And the title alone would suggest that you might expect that families may have some educational rights and privacy rights that they actually could enforce. But the court says, no, you actually don't have that right, and that what you do have is this other administrative remedy that you may be able to enforce, and you let the Secretary of Education know or the Department of Education know, and they'll do something about whether or not your privacy rights that we spelled out in detail and we require institutions to follow, whether they actually have any meaning, rather than go into a court. So it's in that context where I think that it's not a big guessing game. You entitled the thing, the Family Educational Rights and Privacy Act. So certainly you would have some expectation that they have some rights. And certainly in the context of this country, we would think that the expectation of one having rights and where one would have those rights enforced, the most logical place would be a court. So I think that I'm not suggesting that Neil's point is entirely wrong, but I think that, some of the examples that you have in a case like Gonzaga, I think it's sort of off point and doesn't quite work. Because I certainly think that, and that's certainly what the plaintiff thought in that case, is that, well, yeah, there's these detailed rights. I should be able to go and enforce those rights. So I think that I think it's wrong to sort of suggest that if Congress wanted to be more explicit, they should have been more explicit. I think they were explicit enough. And I think that there's some expectation. And I think that Justice Ginsburg in her dissent in Ledbetter, I think, gets at what I think is part of the problem. She has a wonderful quote in there where she talks about the problem with the majority's decision in Ledbetter, where she says that she would hope that the decision would be more in tune with the realities of the workplace and more respectful of Title VII's remedial purpose. And this notion of being, I think, distant from reality and distant from the purpose that the statute was enacted is, I think, really at the heart of what's going on here, is that you have a statute that protects the educational rights and privacy of families and students who go to college and universities. You would expect that right to be able to be enforceable. You would expect Title VII, given its broad scope and its protection of and trying to prevent employment discrimination, that a particular act of employment discrimination with respect to how you treated someone with respect to pay would be within the scope of that act. And that's really what is going on here. It's really this question, as I would like to think about it, as really taken from Justice Ginsburg. It's distance from reality that people live in and what people have a right to expect, and really distance from the purpose of the statute. If the statute is about eliminating discrimination, why would we tolerate that kind of discrimination go on? I mean, at the same time, we have to be respectful and concerned about the rights of the employer, but at the same time, the statute was really intended to root out discrimination. If we're going to allow discrimination to exist and allow it not to be rooted out, then we really haven't really satisfy the needs of the statute. And I think that's something courts can do. Courts should be there making sure that the purpose that Congress had that statute enacted for actually happens.
Okay, so far we've talked a little bit about statutes and the way courts are interpreting them through default rules and through specific decisions that shape the contours of liability in ways that mean that the substantive rights may not be redressable through judicial action, through an individual suit. I want to go a little bit beyond that, and I'm going to turn to you, Rachel Gieman. You're a partner in the New York office of Leaf, Cabraser, Hyman, and Bernstein, which is a large plaintiff-side law firm. You represent employees and consumers. I want to talk a little bit about some doctrines that might seem to be in some tension with this, but that have sort of the same result. In particular, I want to talk, at least briefly, about the idea of federal preemption, restricting state law remedies. There's been growth in this area. We've just seen a recent decision of the Supreme Court in the case of Medtronic versus Regal, which is a case in which federal regulation is held to preempt what is the background law in the United States, which is that there are state tort law remedies when individuals are injured. There's also a growing trend toward recognizing federal preemption from federal regulations. And this has gotten some attention of late because the current administration has frequently placed within federal regulations statements indicating that the regulations, which haven't passed Congress, that the regulations have preemptive effect on state tort law. And in an environment like we've had in the United States for the past 28 years or so, which is essentially a deregulatory, maybe 30 years, a deregulatory kind of administrative law environment. If federal regulations do preempt state tort law, there's going to be a lot of state tort law preempted. So let me ask you about this as a doctrine that maybe leaves people who are injured, at least I don't know if they have rights and no remedies, maybe they have no rights and no remedies, something like that. Can you talk about the scope and the effect of that, and can you talk about that from the standpoint of appropriate judicial action and separation of powers and federalism maybe, and how it fits in with that? So you have 2 minutes. Go. You have more than 2 minutes.
I can't start by just saying I disagree with Neil. And
go ahead.
Yeah, thanks.
He didn't talk about that.
No, I know. It's pretty good.
But he will.
He will, yeah.
Right.
I'll give him a chance.
No, I mean, I think my perspective is informed by doing class action practice, and I think that the problem that Marcia alluded to earlier with the scope of some of the preemption rulings, without going too inside baseball about sort of regulation versus statute and this and that, is that you have a situation where the government, as a practical matter, does not act, and then you have individuals, as a practical matter, who are unable to act. And I think that some of the problem of the kind of discourse around preemption is that it tends to put a lot of things together that really deserve to be kept separate. You have sometimes competing state laws, like the government says, Homeowners Loan Act, federal government can address how much of a late fee you get. You have a state that says on a mortgage loan, the state might say, I think a late fee can't be more than X percent. And you can have a lot of arguments about that, but the kind of reality that we're seeing in this current culture is not so much a fight between a 5% late fee and a 7% late fee. You're seeing companies that just charge late fees when customers aren't even late. You're seeing fraud. You're seeing violations of contracts. And to try to sweep in these very these remedies, these classic remedies in tort, against fraud, in contract, in this instance that I'm using, the right to be able to enforce your loan contract, which means that if I don't pay late, I don't get a late fee. The idea that these things would be sort of deemed as complicating regulations that are screwing up this sacred patchwork of federal regulation is frankly ridiculous. And so I think that there needs to be sort of a change in discourse to remind ourselves that there's nothing there's nothing wrong with judges and juries doing what they've always done, which is identifying and, or, deciding whether, in fact, a fraud has occurred and acting on it, identifying whether a contract has been breached and acting on it. So I'm not sure if that immediately answers your question, but I think it speaks to the need to kind of embed the preemption question in a larger context. It was very troubling in the Regal case to have the majority opinion essentially say that juries applying laws that they didn't make is the same as a government trying to regulate a corporation. So I think that I think it's unfortunate that to some extent, under the rubric of saying we can't have competing regulations, corporations have been able to make a lot of headway in ensuring that people can't even or have difficulties in vindicating their rights under even classic contract and
Can you maybe tell the facts, tell about Regal a little bit?
Yeah, I mean, I'm not, I can. I just
think people.
Sure, I mean, that's a case where, that's sort of a tricky, that's a very specific case. That's when you have you know what, I made a note on this because that is not my immediate area. Oh, Lord.
Perhaps not.
Perhaps not. Perhaps I've lost my cheat sheet on Regal. But, I mean, I could say that generally, to use another example, you might have a case where, the one that's sort of foremost on my mind, because I do a lot of this, is predatory lending work. And an example is a company that allegedly charges late fees, charges attorney's fees, charges various fees even when people are not late, have not done the underlying conduct. And then you have a company that likes to say, well, we can't have willy-nilly plaintiffs' class action lawyers, they don't phrase it like that, but that's the subtext, deciding what is an appropriate late fee. And I think that there is such a gap between that conclusion and the reality of what's happening that that's what, to me as a class action lawyer, is very troubling.
Can I turn back to you, Neil, on this very question?
I think Rachel's right.
Good. Actually, I knew we'd all get along at some point. Tort law and the relationship between tort law and federal regulation, and for that matter, the judicial approach to figuring that out. She says it's not a brutal imposition to have tort law as a background principle.
Contract law, too.
Contract law, too, notwithstanding whatever federal regulation is in place.
I sort of agree with that. And where the sort of multiple voices of the states do conflict, do pose a problem, then Congress ought to be the one to preempt the field, either by occupying the field, either by legislating so exhaustively in the area that there's no room for state legislation, or my preference is, it might not shock you to hear, is an explicit preemption provision. I mean, I'm just astonished that this administration, among all administrations, would be the one to champion the view that in a regulation by a bunch of bureaucrats who were not elected by anybody, they could, by fiat, preempt the entire field of state tort or contract law. I think that's just as offensive as judges inventing cause of action that Congress either didn't intend or didn't provide for. In fact, I think it's probably more offensive on the scale. So, I mean, I have no problem with that at all. I would like to go back, if I can, to Victor's point about Ledbetter, and more specifically about the dissent from Justice Ginsburg. And you point out two things. The one is Justice Ginsburg's allusion to the reality of the workplace. I could not agree more. The problem is that the reality of the workplace also includes a federal regulation that says that the employer is only obligated to keep these files for 2 years. The reality of the workplace is that the average employee only stays with his or her employer for 3 or 4 years in this economy. So the chances of an employer being in a position to defend a decision that was made 5-10 years ago is approaching the vanishing point. Those are the realities of the workplace. We don't have to go far to find them. We can look at the Ledbetter facts. Again, Ms. Ledbetter waited until she retired to raise a decision that was made almost 2 decades earlier. And at that point, the decision maker was dead. Now, let's ask yourself, if you were the HR representative who got called down to legal to say, how are we going to defend this decision? And you say, well, the records were shredded. By the way, we merged and then spun off this entity 4 times since then. The manager's dead. The records, God knows where they are. And even if we could find them, do you expect to have a memo in the file that says, on this date I did not harass Lily Ledbetter and I didn't discriminate against her? Or even a detailed memo that explains, I gave Fred a 3.5% increase and Lily a 3% increase for the following reasons, and then 6 pages of exhaustive notes. That's not the reality of the workplace. So I think that a balanced view of the reality of the workplace has to enter into any consideration of these things. One more point, and that is the statutory purpose, which the argument that we have to construe this consistently with the statutory purposes, I call it the plaintiff's win rule. Because if the purpose of Title VII is to redress the discrimination, then plaintiffs always win. Then we don't need a statute of limitations. We don't need damage caps. We don't need rules of law. Well, there you go. I got the same reception in Congress when I testified on the Ledbetter bill.
You brought a fan club?
No. But, yeah, I knew that's what you meant. The fact of the matter is that every piece of legislation, as complicated as Title VII, has multiple purposes. The purpose for the statute of limitations provision, which is what we were talking about in Ledbetter, is to cut off claims. So if we're going to construe this provision consistent with its purpose, we ought to cut off every claim, which is silly because it's a compromise. It's a package of benefits and burdens. The reason you have an exhaustion of administrative remedies is not to make plaintiffs or their lawyers rich. It's to see if we can't work these things out. I'm being a little flip here, but the notion that we ought to advert to the general purpose of Title VII, which is to remedy discrimination in deciding every question of statutory construction, seems to me to be a default of the judicial process rather than an invocation of it, and that you have to consider various provisions in a statute that are pulling in a constellation of directions and harmonize them all and come up with a sensible rule. And a sensible rule is going to include a statute of limitations for pay cases that isn't when I retire.
All right, Marcia?
Yeah, well, I don't want to turn this whole panel into a debate around Ledbetter because I know we are talking about broader principles and issues. But number one, I really feel the emotional need to respond. But number two, I do want to sort of look at some of the broader lessons of Ledbetter in a rights and remedies context also. The first thing to sort of put in on the table, which none of us have actually really talked about here, is there's another statute of limitations for Title VII cases which remains in effect. And that is when you bring a charge, you can only go back for 2 years to get relief.
Back pay, not relief, back pay.
Well, back pay. And then, of course, you can get relief to go forward. The reason, and the second thing that I want to point out in the context of the Ledbetter decision that has broader application that Victor alluded to, is that there were precedents that had operated so that the way Title VII was interpreted by the Equal Employment Opportunity Commission that actually was on Lily Ledbetter's side of the case all the way through the Court of Appeals, and was only when it got up to the Supreme Court that the Solicitor General and the administration switched sides and argued on Goodyear's side before the government had been defending the EEOC interpretations that had been in effect for 20 years. And there had been an earlier Supreme Court decision in a race discrimination context involving pay. The principle for at least 20 years in every circuit except for the Ledbetter circuit, and I think there were about 10 circuits that had addressed this specific issue, had been every paycheck renews the discrimination. Now she was going to lose 18 years of back pay. She was only going to be able to get back pay for the last 2 years. But the reason and the rationale was not whether she was harassed 10 years ago or not. That really wasn't the point. The point was, is her pay today discriminatory? If the employer has all the evidence and all the information it needs to figure out today, why are they paying Lily Ledbetter less than all the other men who have the similar job? Maybe, and she did testify about the harassment, but that she didn't understand the context and that everybody else was getting paid less. They weren't allowed to even talk about it. I don't want to get more into those facts. But the issue really is first of all, of course, it's the plaintiff who has the burden of proving the discrimination, and that burden remains on the plaintiff. So the elapsing of time is something that will work against plaintiffs because they have to amass all the evidence. But what's key is her pay today discriminatory? And if so, it has to, and she can prove it is, then it has to be equalized going forward, and she can get 2 years of back pay. That's really what was at issue with Ledbetter. So as to the issues now about precedent, one of the questions, and we had Scalia in some cases railing in a certain sense against some of his colleagues who were agreeing with him on the court, that they were in essence overturning precedents without saying so. And that's a part of what Ledbetter reflects as well, with respect to the ability to bring cases in court, with respect to the ability to find private rights of action and implied rights of action, and the way the courts had interpreted them before and the Supreme Court. What we are seeing is those precedents being, if not explicitly overturned, then overturned in fact, and that was part of the uproar in Ledbetter. And I think another interesting issue that's going to come up is a case that was taken just a few days ago by the Supreme Court, and that deals with Title IX. And, of course, Title IX with sex discrimination in education, because of its structure, implicates often Title VI, 504, et cetera. That case that the Supreme Court's going to decide next term is whether Section 1983, which gives a cause of action for constitutional violation, in essence is not available to a person who's been discriminated against in education under Title IX, because now that there's a Title IX, they've lost their 1983 rights. Our tradition in the law has been different overlapping rights are actually a good thing, not a bad thing. And another principle we haven't quite talked about is if you have some right, Victor alluded to it, then you can lose your other supplementary or complementary and reinforcing rights. If the ultimate happens with the Supreme Court holding that Title IX in essence means that 1983 isn't available anymore in the area of education, that means individuals have lost their rights. Plaintiffs have lost their rights to sue individuals. They can only sue the institution receiving federal funds. That's number one. And number two, it also can mean, we don't know, but Title IX as a statute has exceptions in it. For example, for single-sex institutions, and our Constitution, an Equal Protection Clause, doesn't have exceptions like that. So Title IX is a political compromise. If people, because Title IX as compromised as a statute, preempts constitutional claims under 1983, that's yet a whole other avenue of the diminishment of the ability to enforce rights and remedies, as Victor said, in the way people always assume they had them.
All right, so we've touched on, I want to, in a minute I'm going to open the floor up to questions. We've touched on a number of different cases and doctrines that may have implications for whether individuals can bring a suit under different federal and even state laws. And Marcia now raises the question of what's going to happen in the Supreme Court's next term. Before opening the floor up, I guess maybe for a kind of overview, I'm going to turn to you, Victor, and ask you this. So there are these decisions limiting private rights of action. Gonzaga v. Doe limits the ability to sue under Section 1983. We haven't talked about the Sandoval case, which is a case that limits the ability to sue under regulations. Then we get Ledbetter last year, which causes a great deal of comment, both because of its substance, but also, as Marcia suggested, because of its treatment of precedent. Yet this year, just last month, we get two decisions, Gomez-Perez versus Potter and Seabox West versus Humphreys. These are two decisions under anti-discrimination laws, one the Age Discrimination in Employment Act and one 42 U.S.C. Section 1981, which grants everyone the same right as white persons to make contracts. And in both cases, the Supreme Court, I think in one case by a 6-3 vote, in one case by a 7-2 vote, concludes that retaliation claims are available. That is, even though you can imagine reading a statute that prohibits discrimination to do nothing to prohibit the mistreatment of someone who claims discrimination or who reports discrimination, in both cases, the Supreme Court said, yes, there is a retaliation claim available, so that if the person who reports discrimination or seeks to exercise some rights under discrimination law is retaliated against, that violates these two statutes directly. Does that do anything to change the overall picture here, and what are we to make of these two decisions?
I think what it certainly does suggest that in how the Supreme Court has dealt with anti-discrimination statutes, it is complex. You can't simplistically say that the court limits all rights with respect to anti-discrimination statutes. So you can't do that as a blanket statement. But I do think it is sort of consistent in terms of looking at the retaliation, the recognition of retaliation claims in both instances. It's really consistent with the court, at least in these two cases, or majority of the court in these two cases, recognizing the remedial purposes of each of the statutes. Let me just say as a quick footnote, I think Neil makes an excellent point, this concern about if you look to the remedial purpose, you set up a situation where the plaintiff always wins. I understand the point, but I think it's important also to understand that, at least from my perspective, it's certainly the perspective of an organization like the Legal Defense Fund, I'm sure Marcia has a similar perspective, is that I don't think anyone thinks that any time someone wants to file a claim or thinks that discrimination exists, that means they ought to win. I mean, I think it's very, very important to recognize that it doesn't actually help the situation for people who actually have not been discriminated against to actually prevail in discrimination cases, because it doesn't really further the statute, and I think it doesn't do the nation any good. And I think in some respects it actually can breed cynicism about how we're trying to deal with issues, fundamental issues of equality in the country. But sort of back to the retaliation cases, I think that they are interesting, and I think that it's hard to sort of simplify and say, gosh, I'm trying to understand exactly why Justice Alito wrote the opinion in Ledbetter and then also wrote the opinion in Gomez-Perez. How do you sort of reconcile how he sort of analyzed those two cases and came out in that way? I mean, to some extent, he's helped out by the CBOC decision as well, which seems to rely very much on a sort of a stare decisis, and then is able to sort of follow along that line. But I mean, I couldn't sort of simplify and say, yes, I've figured out the jurisprudence that's being followed here, and I understand exactly what's going on. Although, I mean, what is clear in terms of the dissents, because is a different, particularly Justice Thomas's dissent in the CBOCS case, is that he has this notion of retaliation being distinct from discrimination. which is certainly right as terms of distinct acts in that someone may be discriminated against and then someone is retaliated against because they've now reported discrimination or made an allegation of discrimination. But in terms of, as I go back to this whole notion of remedial purpose, about what the statute's about, you can't root out the discrimination if you countenance those who sort of complain about it or those who, and you allow retaliation about those who raise issues of discrimination. So the short answer is I don't have an answer. But it does suggest that the Supreme Court is certainly complex in terms of how it looks at these issues, and that but I think that the Court consistently, we've had in a number of situations, the Court ruling 9-0 on anti-discrimination, in terms of its interpretation of anti-discrimination laws. So I think you can't oversimplify and say, gosh, the Court hates all anti-discrimination laws, or certainly, certain parts of the Court like anti-discrimination laws.
I have another hypothesis.
Yes.
I think that Neil made a comment earlier which was reflected by many, many people of being surprised at the uproar over Ledbetter. I think the Court was surprised at the uproar over Ledbetter. And there have been some Court commentators who have speculated about whether that uproar was something that the justices were immune from hearing and understanding the implications of as human beings. There was some hint of that, I thought, with some of the court reporters who were reporting those decisions, and I actually went to a discussion that one of the justices who was in the dissent in Ledbetter participated in actually earlier this week. And that justice, I thought I heard say that part of what could have been going on in these retaliation cases was these justices having been taken aback by the Ledbetter public reaction. And I want to say that I think that that is something that actually affects the Court, public reaction, both because people are individual human beings and they may see things differently when they feel as if they are really going against the grain of what the public wants. And also because certainly, for example, with Sandra Day O'Connor, where she talked about it explicitly in the context of Roe v. Wade, when she was articulating in the end of the day why it shouldn't be overturned, that a part of what this Court needs to worry about is its credibility and its moral force with the public. Now, one could also be crass about whether there are also eyes to elections and other things, which I would never ascribe to any justice on the Supreme Court and the particular timing of these cases. But I do think that the public outcry over Ledbetter, that the Court meant, as Neil said, there is a Republican alternative, not to go back to where the law had been, but at least to move beyond where the extreme result was in Ledbetter, I think made the justices look very closely at whether they were going to do yet another 5-4 decision saying people are not protected against retaliation, when there had been just a few years earlier with Sandra Day O'Connor on the Court, the Jackson Title IX retaliation case, where the Court had held that retaliation is a form of prohibited discrimination, even if the statute doesn't say we mean discrimination and we mean retaliation.
That raises some interesting questions that maybe you'll explore during questions and answers about the judicial role and what counts as politics and what counts as law. Why don't we open up the conversation to your questions? I have a microphone here, but I don't know.
No, there's a mic.
Is there? Apparently someone else has a microphone up there.
A roving mic.
A roving microphone.
I think that one of the most important barriers that's arisen in the 25 years that I've practiced civil rights law to litigating on behalf of plaintiffs is what's happened to summary judgment. And it's gotten to the point in my jurisdiction in Wisconsin, the Seventh Circuit, where you almost never get past summary judgment, or it's such a rare phenomenon that you virtually have no rights. And I think that it's represented by a trend that I think in general Ledbetter is subsumed in, and some others, which is a trend to sort of front-load cases. What used to be questions of fact are now front-loaded into questions of law by the courts, the appellate courts primarily, and issues of proof, having to do Ledbetter, for example, with whether or not the plaintiff has established a discriminatory motive or not is a question of fact. And what's happened is that juries are being systematically excluded from our system. I think that's a political objective. And I've litigated. I've on the appellate level handled cases where a woman was excluded from a country club, for example, on for certain occasions women weren't allowed, and we got the statute of limitations defense that you've been a member of this club for 15 years, you've never raised it before, your statute of limitations have run. I took that up to the State Court of Appeals in Wisconsin and persuaded them that every time they refused to allow her to come to an event was a new act of discrimination. And the same thing, there are cases in the Seventh Circuit with regard to textbooks. We couldn't have a situation where, for example, children based on race are not given the same quality of textbooks in their schools, and they've been doing it for 20 years, so if you haven't challenged it in 6 months, it's too bad you keep getting the same textbooks. I think that what we need to address is that we have to find a way to make it possible for these cases to be tried in the way they're supposed to be tried, which is in front of juries. And when you have, for example, under Title VII, you have the courts coming in and saying stray remarks. You have the courts coming in and talking about comparators, and as a matter of law, saying, there's no valid comparator here, or this is a stray remark, rather than letting juries decide that issue as a question of fact, is essentially keeping us out of court. And what they've done with the Americans with Disabilities Act in that regard is just atrocious. So I guess I think, to me, that's the most significant thing. You can point to certain salient decisions that catch the public's attention, but the public doesn't realize what's happening. And I think there is a tendency on the part of the judiciary with the conservative agenda to not make decisions that are going to strike down wholesale our civil rights statutes, because that does result in an outcry. What they do is they structure these decisions so that the public doesn't realize. They're not invalidating Title VII, they're not invalidating the ADA, but they're making these decisions that make it impossible to enforce those statutes. And I think that's the most insidious thing that's going on. So I guess I just throw that out for comment.
That's not really a question, but do you want to say something about it? Rachel?
Sure. I think that is very interesting what you're saying. I can offer a couple comments. One, again, from a class action perspective. I think that Title VII employment class actions are hard. They're hard to prosecute. You need to know a lot going in, and there's a lot of issues that are raised. I think that in the summary, one answer in the Title VII context, in the class action context, is I think it's efficient and important for a judge to be able to see, to be able to decide class certification under a kind of Teamsters analysis using the kind of evidence that you're likely to see in this day and age to show discrimination in the context of, in the context of statistics, in the context of perspective on decision making, and to make that decision first before you have summary judgment in connection with some of the named plaintiffs, because I think that it's on the one hand, it's just what I'm saying might seem like a very sort of timing, procedural, who cares issue, but I think it speaks to a question about what, at summary judgment, what does the judge see, and how is he or she able to evaluate that in the context of the modern workforce, and how is he or she able to understand and interpret intent and treatment. And so I think one answer to your question from a class action perspective is get the rule certification issue before the judge, before any summary judgment issues. I think, and probably others on this panel could speak to this certainly more eloquently than I could, but I think that there's a lot of sort of jurisprudential answers to the question of why is it so much easier for employers to get summary judgment now than it was back in when other folks started practicing law. I've never experienced those days, and I wish that I had. I think there's a lot of questions now about how disparate treatment, like in the case of Ledbetter, you are paid less, that is disparate treatment, how that has come to be interpreted by some judges as the need to find a sort of smoking gun of intent that's really difficult to find. And so if you look at the substance of the law against the procedural issues with summary judgment, I think that can be a very dangerous butting up of issues. But
Neil, you do class actions as well. What's your perspective on this?
On which should come first?
Well,
and I think if you have a weak plaintiff, then you're going to want to move for summary judgment as early as you can. And I agree that that's going to color the judge's perception of the class as a whole. The judge is going to assume that this is the best of the lot because they're the named class representative. That may not be the case. I mean,
and it's not the law.
Yeah, there are a variety of reasons why, the person who chooses to bear the standard is not actually the best candidate for that purpose. As far as the use of summary judgment, maybe my view is that there's a much more parochial and self-interested rationale behind the use of summary judgment than some sort of master ideological plan to deny people rights. I think judges are really busy, and they don't want to spend 2 weeks on a trial that they're bound and determined. Plaintiffs are just not going to win. The weak case is weak. They know that if it goes to the jury, they're going to end up having to take it away, or they're going to have to take it away when the jury comes back. I mean, it's a very practical sort of calculus. And so I think most judges, I wouldn't deny that there are some judges out there who are sort of take the bench with a ideological zeal to rid the world of those cases, or to deny summary judgment in every case, no matter how strong the claim for summary judgment is. I think there are judges on both sides of that divide. I think most judges are really careful about it, but they look at the evidence and they say, there's not a chance in the world that the plaintiff gets a verdict or that a verdict survives. And so why put the parties through that pain and angst?
Do you see a shift in what counts as a genuine issue? Or
No, yes and no. I mean, I think that the use of summary judgment and its reception in the courts is cyclical. I think that summary judgments are viewed with greater hostility in the courts of appeals than they are in the district courts, and that's because the district judges are the ones who have hundreds and hundreds of cases on their dockets. And I think that many district judges try cases all the time. They have a better view of what a case looks like. But yeah, I mean, I think it's cyclical, and I think that after the '85 trilogy, the use of summary judgments went way up. Then it sort of began to be received more hostilely in the courts, and you had lots of cases, even after '85, saying that questions of intent are inherently fact-based, and therefore they're almost in every instance those motions are going to be denied. And then you have Hicks, and then you have Reeves, and it's just sort of up and down.
Another question.
I think this gentleman.
It's your call. You're the...
First, I agree with everything he said. I also represent workers for a living, one at a time, not in class actions. And I want to bring up a statute which has the potential to make everyone fall asleep just by naming it, and that is, of course, ERISA. But I think it's a nice example of getting in some of the issues that the panel was talking about, as well as hitting on the point from the audience. And it also answers your question about what will be the statute if we have a national health care plan which requires employers to take actions. Clearly, ERISA would be the statute that currently provides a vehicle I mean, you'd have an ERISA 502A1B claim for
Obviously.
benefits denied.
I see a lot of people nodding.
But the point of ERISA is that you have whole areas of law which are traditional state areas. So doctors used to make decisions, for instance, about what healthcare treatment people get. Sometimes now, as we all know, insurance companies make those decisions. And medical malpractice statutes and state laws designed specifically to protect people from bad decision-making that hurt or kill them or their loved ones have been preempted by ERISA. And ERISA has a standard of review almost all the time, which creates summary judgment almost all the time. The standard of review is arbitrary and capricious. It's a very deferential standard of review. And that means that, for instance, right now, I just took on a case for a guy with AIDS. And he found out he had AIDS after he took a job, and the job had disability insurance. And the disability insurance company, of course, said, no, we've decided that the AIDS must have started in your body before you found out about it, before you took this job. And so on that basis, we're going to deny you. And I'm probably going to face a judge who's going to say, was that decision right or wrong? I'm not going to face a jury who's going to say, that sounds completely wrong. I mean, isn't that the point of disability insurance? No, I'm going to face a judge who's going to say, well, was that completely arbitrary and capricious for that panel of people deciding that? And you know what? There's something fundamentally anti-American about that process of decision-making. That is, in fact, disgusting. And that is what this guy and I see our elegant, elevated legal system of judges who, as far as I'm concerned, are paid more than enough, frankly, compared to how much my clients are paid, and who don't have an enormous docket on the federal bench, and they're sitting around crafting elegant opinions about why people don't get their day in court. And it's really disgusting. It's revolting, and it makes me not want to respect the federal bench and not encourage other people to as well.
That's also not really a question.
Today for speeches. The arbitrary and capricious standard is not the judge's fault. Okay, that's Congress's fault. And listen, I agree that there are 1,000 things fundamentally broken about the way that we handle health care and its administration. On the other hand, I mean, do we really want a system in which a federal judge is going to be, on a case-by-case basis, deciding whether this drug should have been prescribed versus that drug, whether this treatment is the right modality? I mean, I don't think that we can hire enough federal judges to take care of that. So I think that you and I over a beer could probably have a great conversation about a mechanism for fixing it. The mechanism for fixing it is not to give every person who has health insurance a jury trial every time they want to argue over a deductible or whether the company should have paid or the policy should have paid for a chest x-ray or an MRI. It just makes no sense. The system is hideously inefficient as it is and would get geometrically more so if that was the mechanism that we followed. And the degree to which that we're wedded to the jury trial as the end-all and be-all of the only true decider of fact in every aspect of American law, it seems to me, it undermines rather than supports the notion that we ought to have a coherent system that does these sort of things efficiently and without an awful lot of heartache for the people who are beneficiaries.
We have time for one more question. Maybe over here?
Okay, so I also didn't know how to craft this as a question, but since no one else has.
No. It's not the default.
I guess my real question is, what's the fix? I've heard one of the speakers say that it's not a question of getting having a remedy, it's the question of what remedy. But I actually work where the Department of Justice has argued against my cases where I represent federal government employees, and the Department of Justice in 2 of my cases argued before the district court that federal employees, the ones that I represented, even if they had a constitutional right, which they did not concede, there should be no remedy for that right, because the Congress ruled in this enabling statute that created this group of federal government employees that notwithstanding any other law, the administrator can do whatever they want with respect to their employment rights. And the Department of Justice argued that the Constitution is any other law, and therefore they shouldn't have any right, and even if they did have a right, there should be no remedy in anywhere, because they conceded that there was no administrative process to adjudicate these alleged or purported rights. So my question is really, where's the fix? Because as Ms. Greenberger mentioned earlier, you know, the Constitution, when it was created, they did not write, you have a private cause of action. You know, it's not sufficient just to rely on new statutes to give a private right of action when we're looking at older statutes or older documents to establish your rights. And I also questioned, which was more disconcerting, that the government argued that or that the court adopted it. So my question is, where is the fix? I don't think it's sufficient. Maybe in new laws it's sufficient to say Congress needs to fix it, but with respect to applying older laws, I don't know that it's sufficient to say that Congress needs to fix it.
Victor, do you want to take this
Sure.
and wrap it up if you...
Sure, I'll try. Try to get us out on time. No, I do think that the answer, and while I certainly disagree with the notion that there are statutes like FERPA, the Family Educational Rights and Privacy Act, where I think you can say that there should be a private right of action. To the extent that there's concern that there isn't, to the extent that there are other statutes where concern that the rights aren't sufficiently delineated, then one of the things we should do, and part of the notion of a public outcry, is the push to make sure that the legislation is fixed. So, I mean, that certainly is an answer. And certainly in terms of, you know, panel discussions like this, really puts emphasis on what should judges be thinking about, and what are the sort of modes of judicial decision-making that are going to influence how statutes are interpreted. And so I think that that's obviously very, very important as well. I think it's very, very important for, and I do think that the remedial purposes of statutes matter. I mean, it doesn't mean it's a always win situation for plaintiff, but it does matter what the remedial purpose is, and we have judges who are, you know, considerate and respectful, I think is the word that Justice Ginsburg, of the remedial purposes of statutes, I think goes a long way to addressing some of the problems.
Okay, in many ways this has just been the beginning of a discussion. I want to thank our panelists for a most enlightening beginning.